Good morning, everyone. At home, you're listening to me? Hope so. We are here to have a wonderful and fruitful workshop on litigating climate change in international courts through a comparative lens. I want to thank all the staff that has been helping us coordinating this, people in the room and those who are not in the room. Thank you very much for helping us. And thank you, Eloisa, for the idea and all the effort you put in this workshop. I did very little, so the merits are all hers. I like to say this to make it clear. In this first panel, we had, well, one of the speakers had a little problem. She's not going to attend. Margareta Zeverinka Singh from the University of Amsterdam. But Professor Armando Rocha, who is on my left, will replace her. And I also thank him for being here and for the double effort he will make in this workshop, because he will speak twice and probably be the moderator of another panel. So he's the wonder super professor. I'm not surprised. And the order of the speakers will be changed because Natalia Kobilarz had also a little domestic problem and she will have to speak in the first place. So I'll just present everyone who will be here at first, and then I will read a small curricula. Natalia will be the first one, and Armando will be the second, Professor Armando Rocha, to replace Margareta. The third speaker will be Maria Antonia Tigre. She's in the United States. We hoped she could be here with us, but unfortunately she didn't make it. And on the fourth place will speak Dr. Ana Ruiz, who is on my right side here. So I have a small problem now because I will not be able to fully present Professor Armando Rocha because my presentation. Well, yes, I will be able to. But at first, I don't know if Natalia is with us already. She's here. Okay. Good morning, Natalia. Hope you're well.
Good morning. Yes. Can you hear me?
Yes, you can. I'll present you, and then I'll give you the floor.
All right. Perfect.
Natalia Kobilarz is senior lawyer at the Registry of the ECHR. She's lecturer of international human rights protection and environmental human rights at the University of Grenoble-Alpes. She has an LLM degree in international and comparative law from the Southern Methodist University in Dallas, United States. She's got a Master 2 degree in environmental law from the Strasbourg University in France. And she's Master of Law degree from the University of Maria Curie Solowska in Lublin, Poland. Natalia, thank you very much for being here. We are all ears to you.
All right. Good morning, everyone. Thank you very much for your invitation. Congratulations to Eloisa and the other organizers. I hope that you will enjoy this and other panels. This is a very topical question that we'll all be asking and trying to resolve. Thank you for accommodating my wish also to speak first, and apologies finally because I will have to leave you immediately afterwards, but don't worry, this is not a bad thing as such, because being a lawyer at the Registry of the European Court of Human Rights, where 3 climate cases are currently pending and being debated, I would not in any event be able to engage in a great depth conversation with you, because simply I am bound by an obligation of discretion while the judges are deliberating on these cases. So I have prepared 2 slides, and if I could ask for the first of them to be presented. This is a very short introduction of the system of the European human rights in respect to the issue of climate change and the environment. And this will be the first very brief part of my presentation, and then I will tell you about the actual climate cases that have been introduced to the court in relation to climate change. Sorry. So for those of you who are not familiar, a very brief recapitulation of what the European system of human rights is about. In essence, in a nutshell, we have two instruments which are being used. One is the European Convention on Human Rights, which guarantees the whole panoply of civil and political rights through the convention and additional protocols that have been adopted by the now 46 member states of the Council of Europe. This convention does not contain a right to a healthy environment, a right to safe climate, a right to stable climate. So cases that have been brought in relation to the environment, to climate change, have been introduced through other rights. So this is a typical example of this indirect rights-based protection of climate and the environment. So we have issued as the court over 300 rulings, inadmissibility decisions, or rulings, judgments finding violations or no violations in cases which contained different environmental elements. So this is the contentious part of our jurisdiction. We can also, since quite recently, issue advisory opinions, but there are no advisory opinions requests that have been introduced to the court in relation to climate change. You will see that the system is different to what is happening in the Inter-American Court of Human Rights, ITLOS, or International Court of Justice, where requests for advisory opinions have been presented. The European Court of Human Rights can issue advisory opinions, but they are similar to, you may be familiar with the preliminary question that national courts can introduce with the Court of Justice of the European Union. So you need to have a procedure that is pending before one of the highest courts of within the national jurisdiction. That court, if it has been designated by the state to be as being able to request for advisory opinion, can ask the European Court for a question on a legal question on the interpretation of a legal issue, an interpretation of the rights that are guaranteed in the convention. So the scope of this mandate is very narrow. Hence, we haven't had really that there hasn't been any need or any situation in which a request for an advisory opinion regarding climate change could have been lodged. I heard that while the Urgenda case was pending, when it was moving to the Supreme Court of the Netherlands, this would have been the moment where the parties could have asked the Supreme Court to then present the question to the European Court of Human Rights. At that point, it would have been possible, but it wasn't judged necessary. There was no request of that sort introduced to the Supreme Court of the Netherlands. And you know then the outcome, you are familiar with the outcome of the Urgenda case. But in essence, this could have been the situation where the European Court could have issued an advisory opinion. So the contentious cases come mainly under Article 8 of the European Convention on Human Rights. This is the provision that guarantees the right to respect for private life, family life, and for home. And the notion of the home has been interpreted broadly by the court since the 80s, really, or even earlier, as encompassing situations of severe environmental harm that are negatively affecting to a certain, beyond a certain minimum severity, the applicants. As there is no actio popularis under the European Convention, unlike what I understand is the case in Portugal, you always need a direct victim. So you always need the applicant to be able to allege that he or she or it is is directly or potentially affected, but in a personal manner. However, another difference to what you will later hear from the European Union's jurisdiction, we don't have anything that is similar to the Plowman test, which would require that not only the person, the applicant, be affected personally, but also in this peculiar manner, which would distinguish his or her impact from the rest of the population. So we haven't been as strict so far under the case law of the court. And then the other instrument that is being used within the European system of human rights protection is that of the European Social Charter. However, that instrument has its own implementation mechanism. It does not come under the mandate of the European Court of Human Rights. The European Social Charter is being implemented by the European Committee of Social Rights, and one of the mechanisms of the implementation is a collective complaints procedure. Here you have actio popularis, so this is interesting also in this context of the environment. You have NGOs that can bring cases, you have trade unions or as other designated groups that can bring complaints, not cases, complaints to the committee. The decisions that are issued by the committee are not binding, unlike the judgments of the court. But what is interesting here in this system is that there is Article 11, the right to health, which has been interpreted in two cases, in two procedures against Greece, as containing the right to a healthy environment. So this is all I think that is necessary as an introduction to the system. I'm not going to talk about the European Committee of Social Rights. I will now focus on the European Court of Human Rights. And if I could please ask for the other slides to be displayed, that would be great. Thank you very much. So these are the main climate change cases that have been brought to the court. Of course, you are all familiar with the Portuguese case. I'll try to pronounce it well, Duarte Agostinho, I think. So this is against Portugal and 32 other member states of the Council of Europe. We just had a hearing in this case, which lasted the whole entire day. The applicants came all the way from Portugal. They were represented by British barristers and various delegations of the respondent states. They presented their joint statements, joint pleadings. There were many third-party observations that were submitted. Some of them were also presented orally during the hearing. What is interesting is this. So this was the first climate change application brought to the court, followed fairly quickly by that of the Swiss elderly women and the association Verein Klimaseniorinnen, and then you see also the difference between these two cases, apart from the age group of the applicants, is that the impacts which have to be established and those severe impacts on the individual applicants differ. So the Portuguese kids mainly talk about droughts and forest fires that are induced or made more frequent or heavier by climate, by global warming. Then in Klimaseniorinnen, it is about heat waves, which allegedly put a higher risk of death and illness, especially on women and especially of women of certain age. Then the other cases that we have received was an individual application against France brought by a mayor and an individual, by a person who was at that time a mayor, but also it was in his private capacity of a town which is on the coast. And the alleged risk here of the alleged impact of climate change is that of rising sea levels. Then we had a case brought by Mr. Milner against Austria. So as you can see in this photo, he's a person who suffers from a particular medical condition, which makes his situation more difficult and specifically speaking puts him in a wheelchair when the temperatures rise beyond 25 centigrades. And then we had a different angle of climate cases, those brought by Greenpeace against Norway, and these concerned especially specifically licenses for oil exploration in the Barents Sea. So the argument here is that agreeing or authorizing those exploration licenses is contradicting the Paris Agreement obligations and commitments that were undertaken by Norway. Then we have yet another angle, more political still, Subeste and others against Austria and 11 other states. These cases concern the Energy Charter Treaty, and the argument is that the states who are signatories to that treaty cannot meaningfully mitigate climate change because they are bound, they are obligated to respect the contracts and commitments and agreements with investors, with fossil fuel companies. And then an interesting also situation, this time legally, is the case of Engels and others against Germany, which is a follow-up to the case which may be familiar to many of you, Neubauer, against Neubauer, which was decided by the Constitutional Court of Karlsruhe. And the particularity of that case is that the judgment issued by constitutional judges of Germany condemning the policy and the Climate Act, which was operating at that time as non-compatible with the commitments of mitigation of climate change with respect to future generations, that judgment generated a change of law, and a new Climate Act was adopted by Germany with higher targets, and yet a group of applicants still come directly before the European Court of Human Rights to claim that this new act, these reformed provisions, are still incompatible with the 1.5 temperature target, and they're asking the court then to decide on this case. So you can see that there are many issues, technical issues that are involved related to the impacts which are connected to each and every single applicant here or group of applicants. There are legal issues under the European Convention that are raised in respect to the legal standing of NGOs, such as the Klimaseniorin Association, whether they can complain or to which extent they can complain about the physical impacts on the population of their members. On the other hand, we have those political questions asked in the Austrian case, and the questions of sort of follow-up and subsidiarity principle in the German case, and many other issues that are novel under the European Convention on Human Rights that will be discussed in depth by the panels that will follow. So I'm not going to delve into this. Just so you know, these cases were taken up by the court with priority. Duarte was communicated within several months. Same thing for the Swiss case. Communication means that the court notifies the case to both parties and then asks for the pleadings. And then also fairly quickly, it was decided to join certain cases together, namely the Duarte case, Beren Klimaseniorin and Carême, and all three of these cases have been relinquished to a grand chamber of the court. When the grand chamber of the European Court of Human Rights assumes jurisdiction over a case, that is because the judges feel that the cases raise novel issues or issues of importance to both the implementation of domestic law and of the convention in the member states. And yes, you will hear throughout your seminar what these issues are and what these legal questions are. So anything can happen now. All three cases have had their hearing now. The judges have deliberated. There was a lot of attention on these cases. In the meantime, the other cases, the Norwegian, which was also communicated, and the non-communicated cases, unnotified cases, they were adjourned. This is the usual practice of the court. So the judges, the 17 judges of the Grand Chamber, will deliberate in the 3 main cases, and then the rest of them will follow suit when we have the rulings, which I think it's reasonable to expect them to come in the first part of the next year. In the meantime, we receive copycat applications, if you wish. So there were 2 applications against the UK. Now we have cases against Spain as well that are brought, and that are brought by people who don't necessarily specify what exactly they're complaining about. They are copying some of the complaints from each of these cases, mainly from Duarte, and without exhausting domestic remedies. Just like in Duarte, they come directly to the European Court asking for a ruling. And 2 of these cases against the UK so far have been declared inadmissible on the grounds that the applicants did not make that case. They did not sufficiently explain what is the relationship between them and, for example, industrial animal husbandry and climate change. So the cases that are not really developed sufficiently for the court to find any substance in them, or substantial grounds to establish that the people who are bringing these cases can claim to be victims. So I think I will stop here. Thank you very much for your attention, and I hope that this is a good basis now for the other speakers to present the other jurisdictions, for you to understand the differences, and like I said, for the panelists from the later panel then to tackle the specific issues which are under international human rights law. Thank you very much.
Natalia, for your clear and concise presentation. I will now give the floor to Professor Armando Rocha. He is a professor of law at Católica Lisbon School of Law, a researcher at Católica Research Center for the Future of Law, also a visiting professor at the University of San Jose, Macau, China, and also at the Catholic University of Lille, France. Global PhD program in law from Catholic University of Portugal. He has kindly accepted to replace Professor Margareta Viveringa-Sink. He will give us a brief overview of the features and trends of climate litigation in the United Nations system. Thank you very much, Armando.
Thank you very much, Professor Carla Amado Gomes, for your kind words, and also to you and to Professor Heloísa Oliveira for putting all of this together. For those who have ever organized a conference, you know that this is very time-consuming, bureaucratic, etc. So thank you very much for this effort. So I have a difficult task here because I need to put myself in the shoes of Professor Margareta Viveringa-Sink. So for those who are expecting something very proficient from her part, now I need to be leveled up to your expectations. So without further ado, I will start and hopefully speak in only less than 15 minutes. And as we all know, looking for a black letter legally binding obligation to reduce greenhouse gas emissions stands for us as international lawyers as the potion of life for alchemists, an obligation that can be used as a catalyst for state action and a legal argument before courts in case of state inaction. But contrary to the philosopher's stone, our hope is that legally binding obligations under international law can be found and brought to courts more easily. But surprisingly enough, looking for such binding obligations and enforcement fora has been more a matter of experimentalism and creativity. So the obvious starting points are Article 4 of the UNFCCC, which is already de facto superseded, and Article 4 of the Paris Agreement, which is clear in mentioning states' obligations to prepare, communicate, and maintain successive nationally determined contributions but not commitments or obligations, which will represent, but not shall, a progression over time and reflect a state's highest possible ambition. Explicit in this latter provision is only a procedural due diligence obligation of means, but still a legal obligation, and obligations of means, they are always goals-oriented. The problem is that this and other provisions of the Paris Agreement, they are open-ended, they use a low-density wording, and voice soft, light, or uncharacterized obligations at best. Because the devil lies in the detail, proving non-compliance with the Paris Agreement is a daunting task for lawyers. And the icing on the cake is that the Paris Agreement, just like the UNFCCC, heavily relies on facilitative and light compliance processes. True that there is a common dispute settlement clause under Article 14 of the UNFCCC and 24 of the Paris Agreement, but the lack of acceptance of the jurisdiction of the ICJ and the arbitral tribunal implies that there is no prospect for state-to-state litigation under both treaties. Even most of the small island states in the Pacific did not accept this jurisdiction. So at first sight, the prospect for using both treaties in climate litigation is as elusive as finding the philosopher's stone, unfortunately. And this is a design flaw and a design choice at the same time. Being state consent the basis of the international obligation, meaning the basis for its emergence and for its enforcement, litigation under the UNFCCC legal complex is close to impossible. On the one hand, because we are dealing with hard law treaties conveying soft law obligations. On the other hand, because their dispute settlement clauses are unlikely to be triggered in the near future. But how is it that the biggest environmental harm ever caused can get off the radar of international law? Solid legal grounds for climate litigation that cannot be a figment of imagination, and a proper forum for adjudication must be sought and found. So perhaps testing a new or having a new testing ground can be enough. For instance, some authors have suggested using the general jurisdiction of the ICJ under Article 36, paragraph 2 of the ICJ Statute to bring non-compliance with the Paris Agreement into the ICJ, alternatively to Article 24 of the Paris Agreement. But that would actually destroy the very function, object, and purpose of Article 24 of the Paris Agreement and create a dangerous precedent for the interpretation of similar treaty clauses. But one thing we can learn from old-time alchemists is that the potion of life would not be prepared with one ingredient alone. So a different testing ground and a different formula can be key if we want to bring climate change law into the international judiciary. From a substantive angle, climate change law is still environmental law, fortunately, meaning that it shares principles, concepts, rules, and doctrines. If these are helpful, that's a completely different story, but at least no one really discusses the relevance of the no harm principle, for instance, or the precaution and or the prevention principles. And moreover, there is an already established case law on the specific obligations stemming from these principles, which include the duties of cooperation, monitoring non-state conduct, or conducting environmental impact assessment studies. Looking to environmental law helps substantiating climate-related claims, but does not provide an alternative enforcement forum, as Article 24 of the Paris Agreement is still lex specialis vis-a-vis Article 36 of the ICJ Statute. So alternatively, we can look to the Law of the Sea Convention, whose Article 1st defines pollution very broadly and includes the introduction in the marine environment of substances as greenhouse gases or energy as heat. And it sets out a state-to-state dispute settlement system that can be used in case of non-compliance with Part 12 of the UNCLOS. Plus, human rights law, as we have just seen, including special conventions such as the Conventions on the Rights of the Child or the Persons with Disabilities. Those treaties within the UN system, they are also open to states. As climate change creates a great stress to the enjoyment of human rights, my colleagues in this panel, one has already explained you how regional treaties have or can be used and how they can provide a moral standing to climate-related claims, although they are not a silver bullet. But my task now is to highlight that states can, but do not, resort to litigation under human rights treaties, just as they avoid litigation under the UNCLOS or under any other treaty at all. First, because they are afraid of damaging their diplomatic relations. Second, because they are afraid of retaliation. And let's be honest, if climate change was an Agatha Christie novel, it would be The Murder on the Orient Express, where all characters were found guilty of that crime. So asking courts about other states' obligations is also to ask about one's own obligations. So it's not a coincidence that state-to-state claims are confined to the Conference of the Parties of the UNFCCC, and climate-related litigation has been brought into international courts by non-state actors. Then we have a third explanation. A climate-related claim before a court is the very definition of probatio diabolica. Issues such as standing, causality, non-compliance, extraterritoriality, or even climate science can be difficult to prove in court. So this explains how and why we have ended up in this situation. Individuals have used their ecumenical access to human rights bodies to submit climate-related claims against states. The UNFCCC and the Paris Agreement have been successfully used in domestic litigation, as in the Urgenda case. And state-to-state litigation is difficult, but possible, except that states are not keen to use it. What if then we could bring the same formula and ingredients to a new testing ground? What if we could instead bring climate change law into international courts by means of advisory opinions? Being facts and disputes detached means that we don't need to damage diplomatic relations or fear retaliation or prove anything in court. And because judges are not limited by the intricacies and the specificities of a case, they can better develop the key principles, concepts, doctrines, and rules of climate change law, which can then be pivotal in future climate litigation. This explains why, in the span of 3 months, 3 requests for an advisory opinion were submitted to the ICJ, the ITLOS, and the Inter-American Court of Human Rights. So for the first time in history, an entire field of international law will be inaugurated by means of advisory opinion by 3 courts at the same time, in the absence of any precedent and any meaningful state practice. And common to the 3 requests is that they refer to every single possible source of any legally binding international obligation, ranging from the UNFCCC and the Paris Agreement to human rights law, the law of the sea, or environmental law. So for those who are concerned with the urgency of climate action, and correctly, this is clearly disappointing. But Rome wasn't built in a day. As the case law on climate change law will be inaugurated by these advisory opinions, clarifying the bedrocks of the legal regime, clarifying the key principles, rules, concepts, and doctrines, and fleshing out clear, even if limited, states' obligations can be decisive and wide-changing contribution to climate litigation. Plus, as scholars, we are aware of the importance of trial and error. And sometimes we learn more with a failure than with a success. So to sting a court and see how it reacts can be very helpful in future litigation. And finally, as I'm running out of time, I imagine, courts' pronouncements, they are authoritative. And because symbols matter, judicial decisions, judgments, or advisory opinions, authoritativeness is ingrained in the genetics of the institution, not the act itself. But their pronouncements, they can help prioritizing climate action and act as purveyors of legitimacy. Because they cannot replace states in the making of value-based choices, courts need to walk fine lines to avoid being perceived as intrusive. So opinions can actually be very useful, and useful as a first and non-intrusive testing ground to encourage state action at the domestic level. So much less encouraging than what Natalie Kobilar has mentioned about the European Convention on Human Rights, but still there are some few good prospects under the UN system. Thank you very much.
Thank you very much, Professor Mandorosha. Maybe we can find the philosopher's stone after all, but the trail is hard and slow. But there's light at the end of the tunnel, listening to you.
Hopefully.
Yes. A little of wishful thinking, which is absolutely necessary in this climate change matters. On the third place of our first panel, we will hear Maria Antónia Tigre. She has a PhD in juridical studies at the Elizabeth Haub School of Law at Pace University, obtained in 2022. She joined the Sabin Center for Climate Change Law at Columbia Law School as Global Climate Litigation Fellow. She serves as the Deputy Director of the Global Network for Human Rights and Environment, and she's a member of the IUCN World Commission on Environmental Law. Maria Antónia will bring us to the to the Latin America system. Thank you very much, Maria Antónia. It was still not this time that we meet personally. I hope you are well. We give you very warm welcome, and we are anxious to listen to your presentation. Thank you.
Thank you so much. Thank you for this wonderful invitation. I was really sad not to be there in person, but maybe next time. And I have to say, it's really hard to follow Armando. I don't think my presentation would be as eloquent, especially considering that it's 5 a.m. here. But I'll do my best to sort of explain the Inter-American human rights system and how that fits in with all of this conversation of advisory opinions. So, just very, very briefly, the Inter-American system of human rights consists of the Inter-American Commission and the Inter-American Court. And, states have to first go through the commission, or not states, sorry, stakeholders in general need to first go to the commission for then the case to be referred to the court. And that usually takes about 20 years, which has sort of been the norm for the Inter-American system in the past. So you can see how any type of climate claim that would be brought now would definitely not be resolved within the time frame that we needed to. So that's part of the brilliance of actually requiring this advisory opinion from the Inter-American Court. And, sort of going back again a little bit, the way that Natalia explained the European system, I think it's helpful to know that the American Declaration sort of forms it's the treaty that forms the basis for the inter-American systems norms, and as well as the San Salvador Protocol, which was adopted later on. The American Declaration doesn't include a right to healthy environments. The San Salvador Protocol does, but it hasn't been ratified by all of the states that are part of the American Convention, the American Declaration. So it has some limited applicability. It also has some justiciability issues that limit its application further. So in 2017, actually, there was another advisory opinion that was requested by Colombia related to how human rights apply to environmental issues more generally. And in that advisory opinion, which was published in 2019, the court actually recognized the right to a healthy environment as being, an implicit within the American Declaration. So that was a very significant recognition of the court. So it was really sort of a transformative interpretation, because the court said that the American Convention was a living instrument, and specifically directly and indirectly justiciable within the declaration-based contentious jurisdiction of the San Jose Tribunal. So that really brought environmental degradation and climate change more generally within the inter-American system of human rights. After that, in 2020, there was another decision in a contentious case, actually, which was called the La Cajonhead case related to indigenous communities in Argentina. And in that case was really the first time that the right to a healthy environment, along with the right to cultural identity, food and water, were actually applied autonomously based on the same interpretation from the advisory opinion, but in a contentious case. So really, shortly after the advisory opinion that was applied. So that was a significant development in terms of the jurisprudence of the court in general, which really led to this moment that we are in right now. And in addition to that, we also have the Escazú Agreement, which was adopted within Latin America and the Caribbean also in the past few years. And it is applied as a human rights treaty, can also be applied by the Inter-American Court as well. And that specifically recognizes the right to a healthy environment, along with, a series of other rights, like the rights of environmental defenders and so forth. So that also, that all forms sort of this new scenario that we're talking about, in which, the court as a human rights court is actually way more favorable to perceiving, issues of environmental protection and then climate change more specifically. So in addition to all of that, we actually have had a couple of cases within the inter-American system that I'll briefly mention. 4 cases, actually, in total. 1 was dismissed and 3 are still pending. So first of all, I think probably everyone has heard of the Inui petition, which was brought in 2005. So it's really, it's perceived as the first human rights, the first rights-based climate case. So it was a petition brought by the Inui group against the United States, basically seeking relief from human rights violations resulting from the impacts of global warming and climate change caused by acts and emissions of the United States. So it was really the first time that this novel set of legal arguments were brought to a court, and really brought the voices of marginalized communities as well, obviously against a very powerful state. It had some mitigation and adaptation claims. And that case is really, interpreted as being is spearheading this rights-based movement that we see now, in courts very broadly around the world. So the problem, obviously, there are several problems with that petition specifically, but it was difficult to prove harms under the traditional legal framework because of causality and scientific uncertainty and that drop in the ocean argument. Obviously, that was a very, very different time. I think several of these issues are no longer issues through interpretation of several courts around the world. But the case then was not successful. So the case was dismissed, but it really opened the door for this, this link between human rights and climate change to be then developed by courts around the world. There's another petition that was brought in 2013. It's called the Athabascan petition, which is very similar in a way because it also relates to Arctic warming, but it was related to Canada's carbon emissions. And basically the Arctic Athabascan Council asked the Commission to declare that Canada's failure to implement adequate measures to reduce its black carbon emissions violates rights affirmed in the American Declaration, and then recommend that Canada take steps to protect the rights of these people and limit black carbon as well. So that petition is still pending. So, it's been 10 years, nothing has happened with it yet. So that sort of reinforces that point that the process is very slow. There's another petition that was brought in 2021. It's called the Cité Soleil petitions related to this community in Haiti. It's actually a case that is not purely a climate case. It's more related to waste disposal in this residential district in Haiti and how that, toxic trash disposal affects children specifically. But it does discuss, in the initial petition, it does discuss climate change's aggravation of the harms of children through environmental displacement, food and water insecurity, and exacerbation of waterborne diseases. So that is also still pending, but an important case also that eventually will be recognized. Then the other two important developments that are worth mentioning is that after the Inuit petition was dismissed, the Commission actually agreed to hold a public hearing on human rights and global warming. It's called a hearing of a general nature. So it was at that point, it wasn't very transparent. So there's not a lot of information of what happened there. But then a decade later, they held another hearing on climate change and human rights based on a petition, a request for a hearing that was filed by a group of NGOs, specifically focusing on the impacts of climate change on human rights of groups in situations of vulnerability, including Indigenous peoples, women, children, and rural communities. So it was a thematic hearing, not like a case per se, but also important to push really the human rights system into this dynamic interpretation of the law, considering these new issues. And then finally, there was a resolution that was published in 2022 by the Commission and Brdesca, which is the special rapporteur within the Inter-American system on environmental and some other rights. So it's a resolution systematizing the human rights obligations of states in the context of the climate crisis. It's a very detailed resolution. It's a long one. I think it's really worth reading because they touch on, a series of issues related to climate change and really builds on the advisory opinion that I mentioned on human rights in the environment, adopting this rights-based approach to climate change and commitments under the UNFCCC and policies for energy transition and so forth. So, that also forms this new legal framework that is expanded. And one thing that I forgot to mention that this resolution also expands on from the advisory opinion is this issue of extraterritorial obligations of states in environmental and climate matters. So that was something that the former advisory opinion really expanded on. saying that there is an extraterritorial responsibility and clarifying that this rule of do no harm would be breached as a result of greenhouse gas emissions, and that that came from the resolution as an expansion of the advisory opinion, and that the resolution also said that the increase in frequency and intensity of meteorological phenomena it's attributable to climate change, which cumulative contribute to this emergence of adverse effects in other states as well. So, they specifically talk about its obligation to prevent transboundary harm in mitigation targets as well, and the level of ambition that is consistent with the Paris Agreement in the resolution. So it's not a binding resolution. The court doesn't necessarily need to follow it to the letter, but it is a recommendation that's coming from the same legal system. So, I think that in general sort of brings this fertile ground now for the advancement of climate litigation, in addition to, obviously a series of developments that have occurred at the domestic level as well. And all of that leads us to where we are now, right? Because so in the beginning of the year, we had this request for an advisory opinion that was brought by Chile and Colombia to the Inter-American Court. So again, like Armando said, sort of a way of bypassing, that problematic and long process of coming first to the commission. Then that I said would take about 20 years. With these advisory opinions, usually a time frame of 18 months for the court to actually issue the advisory opinion. It might be a little longer at this time, considering that they've been extending the time to submit amicus briefs, but it would still obviously be a lot faster than the traditional processes and bypassing the facts and issues of attribution science and all of that, which would make it complicated. So specifically the request concerns states' climate-related obligations under the American Convention and really clarifying the involvement of Latin American states in the climate emergency. It really presents this opportunity to mobilize the state apparatus within the context of human rights and deploying the international level to tackle issues of climate change, in addition to measures at the national level as well. So the way that this happened was that an international organization actually approached Chile and Colombia and lobbied them to make that request, because only states can make those requests. States that are members of the Organization of American States can request advisory opinions to the court. And Colombia obviously has requested that other advisory opinion before, so it's sort of a logical approach. And then Chile as well, it's a very pro-climate government that sort of leaned itself better to making such a request. And then, it was a way to address the urgency of the climate crisis, and the procedure in and of itself of an advisory opinion is also very both transparent and inclusive, because differently from the ICJ and ITLOS, actually anyone can submit amicus briefs, and that's why the deadline to submit amicus brief has been extended so many times, because organizations have been really lobbying the courts to allow for that process to be really inclusive. So it's expected that there will be more than 100 amicus briefs. Literally every organization that I talked to said that they're going to submit something, in addition to all states within the Organization of American States and potentially some other states. Like I've heard that Germany would potentially be submitting something as well. Us at the Savings Center, we are submitting something. So, and obviously on different topics as well. So, moving to the context, to the content of that very quickly, because I think maybe I'm already pushing my time limit. I'm sorry, I was supposed to look at it more carefully and I didn't check at the time that I started talking. But the request, unlike the request to ITLOS and the ICJ, which are more concise and specific, it's actually a very long one. So they have about, I think, 20 questions, which relates to a wide variety of issues within climate change, including, vulnerable communities, how that impacts like women, children, Afro-descendant and indigenous communities, protection of environmental defenders, specifically rights of future generations as well, peasant communities. They ask about differentiated and shared responsibilities of states and cooperation between countries in the region, judicial remedies and consultations on climate impacts, climate migration, and forced displacement as well. And then obviously, more in line with what was asked to the ICJ, and it allows more specific questions related to prevention and guarantee of human rights linked to climate emergency, then climate mitigation and adaptation measures, and responses to prevent, minimize, and address economic and non-economic loss and damage as well. So specifically, it's the only question, the only request for an advisory opinion that specifically asks about loss and damage, although, it might be that ICJ will address that. It's very likely that it will address that based on some of the, comments and the lobbying from the Pacific states as well. But we can really see how this question is actually a lot broader. So the court has the possibility to actually change the question. So we did that for the previous advisory opinion. It was initially a question that related much more to marine resources specifically, so they made it broader. So it could still change part of it, or not address all of those questions, but it does seem like it would be a more comprehensive one. The court is also perceived as a very progressive court, so it's an expectation that it will be, that it will similarly have a very progressive response to these questions as well. So it really has the potential to establish these climate-related norms for Latin America and the Caribbean, and have the opportunity to really shed light on some of these pressing issues by interpreting international and regional human rights and environmental instruments to determine whether and to what extent states have obligations to confront climate emergencies in the context of the Inter-American system of human rights. And then, Armando mentioned a little bit of this. Obviously, there's this competition that happens between courts. All of them eventually will be interpreting the UNFCCC and the Paris Agreement, in addition to obviously other norms. So there is some risk there as well. And it was very much expected that the Inter-American Court would have the advisory opinion published first. I think now with these delays, it seems likely that the ITLOS will come first, then the Inter-American Court, and then ICJ. So I think maybe I'll stop there, and I'm sure we'll have lots of interesting discussions throughout the day, and I'm happy to discuss more in the Q&A too. Thank you.
Thank you very much, Maria Antonia. You were a little ahead of your time, but it's okay. It's still okay. I will very briefly present Dr. Ana Ruiz. She will give us an overview of the European state of affairs in these matters. She's a policy analyst at the European Roundtable on Climate Change and Sustainable Transition. She is a qualified lawyer in Portugal. She has an LLM in Global Environmental Law and Governance from the University of Strathclyde. And time's running. The floor is yours. Thank you very much for being here.
Thank you very much, Professor Carla Amado Gomes, Professor Luisa Oliveira, and Margarida Sampaio for organizing this very much needed workshop at our university. The slides now. I won't definitely be as eloquent as Natalia and Professor Armando and Maria Antonia, so please bear with me. Is everyone seeing the slides? So my presentation focuses on climate litigation brought before the Court of Justice of the European Union, which is, in my view, a very timely analysis, not only considering the global phenomena of climate litigation as a whole, but especially considering Europe is undergoing, as we know, an unprecedented shift in the ambition of climate policy, reflected in the prolific legislative production. I'll start by doing a panoramic overview of the cases brought before the Court of Justice. Since 2005, around 70 cases, 71 to be precise, have now been filed before the Court of Justice and its predecessors. The Court of Justice is divided in the General Court and Court of Justice. Most of the litigation brought concerns the EU emission trading system. Around 43 cases are about this topic that I will further explain a bit so everyone knows what I'm talking about. The most one ETS case was decided in 2017, and the most one filed this summer in July by Poland. The remainder litigation, that is meaning the non-EU ETS litigation, cover a wide range of themes related to the core of climate change, but also related to EU environmental law more generally, like topics concerning, for example, access to environmental information or access to justice in environmental matters. These cases have generally been non-strategic, meaning they do not pursue a broader legal, political and policy change, and essentially they have led to favorable outcomes for climate action. Sorry, next slide, please. Visually, we have this scenario. We can easily attest that there's a changing in the trend of EU ETS litigation, from EU ETS litigation to non-EU as litigation, but that won't necessarily stay that way, as I will as well explain further. Next slide, please. Before delving into the features of ETS litigation, I will do a brief explanation of the EU emission trading system, so everyone in the room here and online knows what it is. The EU emission trading scheme really emerged as the cornerstone of the EU regulatory response to climate change. It is a cap and trade system that aims to facilitate decarbonization cost effectively. The cap sets a limit on the total amount of greenhouse gases that can be emitted by installations in the EU, and this cap is being reduced. The cap is expressed in emission allowances that companies buy on the EU carbon market by auction, but they can also be freely allocated. This measure of free allocation intends to avoid carbon leakage. That is the phenomenon that industries relocate abroad and go to non-EU countries so they can avoid paying a carbon price, and also to ensure a level playing field with non-EU countries. This measure is now is ending in 2030 and is being replaced by the Carbon Border Adjustment Mechanism, the CBAM, that makes imported goods pay the same price for carbon as goods produced in the EU. This, I'm sure, will lead to EU litigation very, very certainly. These revenues, auction revenues, are then used by member states in the climate transition and energy transition. The EU ETS directive has been heavily litigated by corporations and governments between 2005 and 2015. more than 32 cases were filed regarding EU ETS. The Court of Justice issued 28 decisions favorable to climate action, 6 decisions unfavorable to climate action, and 8 decisions with a neutral outcome. Most of the EU ETS cases have been non-strategic in nature. Thank you. They usually concern exclusively the application of a specific set of rules in a specific set of circumstances. Most of the cases, again, are related to free allocation, if certain installations can benefit from free allocation, and if certain installations can are covered for ETS or not. Next slide, please. Yes. The corporate... ótimo. Obrigada. Ok, boa. Muito mais fácil. Corporate claimants have, largely from heavy and energy-intensive industries, have had little success in the Court of Justice, with most decisions being favorable to climate action. Most of the claims were dismissed, indeed, on the basis that these corporations could not sufficiently demonstrate that they were individually affected by the Commission's decisions and by the regulation. Cases brought by governments, on the other hand, have seen some success, resulting therefore in outcomes deemed unfavorable to climate action, mostly related to the national allocation plans and the lack of discretion that the Commission has within that context. Before these 2 cases that the Commission brought against Estonia and Poland, there were 2 cases that actually were favorable to climate action that the Commission brought against Italy and Finland regarding the lack of implementation of the EU ETS directive. However, this active enforcement of the directive through the Court of Justice does not remain and doesn't remain a common practice. Yeah. Now, concerning non-EU ETS cases, the topics revolve around access to justice in environmental matters and environmental information, biodiversity, environmental impact assessment, also the qualification of renewable energy, and as well more recently regarding EU climate ambition as a whole. Before 2015, most of the cases were non-strategic. Only 1 out of 14 was seeking a broader change in the EU's legal policy regime. And after 2015, which marks the 3rd wave of climate litigation, most of the cases, 11 out of 13, have been strategic in nature, therefore reflecting the growing sophistication of applicants seeking to use the Court of Justice for both climate-aligned and non-climate-aligned litigation strategies. The claims have been brought by a mixture of corporations seeking to challenge EU policies, public interest, NGOs, and governments. And the outcomes have been generally favorable or neutral to climate action. It is worth mentioning, I know this will be acutely talked about in the following panels, but it's worth mentioning 2 unfavorable recent climate cases that were dismissed on standing grounds, and the Court of Justice didn't make any findings on the merits They were the EU biomass plaintiffs and the Hermano Ferrão Carvalho. More recently, we have been in these 2 years, we had 4 cases regarding the EU taxonomy related to the qualification and labeling of types of energy as green or environmentally sustainable investments. Finally, to wrap up, until last year, if we go back to that initial graph, shorter, until last year, there were declining litigation before the Court of Justice, perhaps here in favor of the European Court of Human Rights. As Natalia mentioned, the Court of Justice has a very strict approach concerning actio popularis and the direct and personal interest of the claimants. We can also attest the fact that litigation brought before the Court of Justice did not properly accompany the pace of European Union legislative production. We see, of course, a trend of strategic litigation instead of non-strategic, climate aligned or non-climate aligned. And also it is worth to point out that there's still, again, the barriers of standing, which is a hurdle to bring climate aligned cases before the Court of Justice. Future trends, there will be definitely a growing number of cases brought before the Court of Justice, following the Fit for 55 package that intends to implement the European Green Deal and the climate law, the extension of the emission trading scheme to buildings and transport will, again, building on history, will lead to an increasing number of cases regarding that topic. The carbon border adjustment mechanism will definitely be something the courts will have to deal with. Stakeholders have been very vocal about this measure, and this indeed can escalate the litigation even to WTO bodies. And the Renewable Energy Directive 3, Euro 7, CO2 standards for light vehicles and heavy-duty vehicles will also lead, I'm sure, to litigation, especially because they exclude the use of renewable fuels. Here, climate non-aligned cases, and they exclude the use of combustion engines after 2035. And yes, a lot of the Corporate Due Diligence Directive, the Net Zero Industrial Act, raw materials, CCUS, the carbon capture and usage storage strategy that the EU will also implement next year. All of these legislation will certainly lead to a growing number of cases before the Court of Justice, as also we can already see for cases that Poland brought in July, challenging the CO2 regulation standards for light commercial vehicles, the ETS, the LULUCF, and regulation on binding annual greenhouse gases emission reductions by member states. And yeah, voila, c'est ça. Thank you very much.
Thank you, Dr. Ana Ruiz. We have a little time, like 10 minutes, 15 minutes, because we didn't start at 9:30, but at 9:40. So we still have 15 minutes to questions, and I'm going to give the floor to the public, and I'm not going to say anything to change this rule that the public has priority. Margarida, first, no, please.
Okay. So I have a couple of questions. So I'll start with this one. The biggest difference that Okay, perfect. The biggest difference we have between the Paris Agreement and the Kyoto Protocol is that one it's a top-down solution and the other one it's a bottom-up. So especially in this recent case, Duarte Agostinho, it's interesting that one of the countries that decided to defend himself individually was Turkey. And Turkey decided to argue that they were not part of the Paris Agreement by the time of the events. Do you think that if the regional courts start to analyze this question, will the parties of the Paris Agreement start to withdraw? Because in the end, international law, it's based on the will of the states and as you presented. My second question is the difference between international courts and regional courts. They present totally different solutions. Regional courts, it's more difficult for them to handle questions of shared responsibility since this is a global problem. But in the other end, for individuals to assess the court, it's possible. How do you think that we can compatibilize these two different solutions? Because as you explained, Armando, they are different ingredients and we need more than one ingredient, but should we focus in one before focus on the other? And my last question is regarding the EU jurisdiction and the relation to the European Court on Human Rights. Do you consider that if the EU finally accesses to the European Convention on Human Rights, can we have some difference in this litigation before the court?
Thank you very much. Your name is? Francisco. I think you addressed your questions to Professor Armando.
Yes, and the last one.
Yes, yeah. I was wondering who would be the perfect one to answer. Maybe we will join some questions so we can accelerate the process. Margarida, you wanted to ask something?
Thank you. Thank you very much for all the presentations, very enlightening. My questions are not actually mine. I'm reading the questions in the chat. We have two questions from our the people that are listening to us right now. The first question, I think it was posed while Professor Natalia was speaking, but I don't think she's still here. Otherwise, I think it can be answered by any of you. The question is as follows. The governments of many European countries have adopted and applied harsh measures to repress peaceful climate protests. Have any cases, to your knowledge, been brought to the European Court of Human Rights to challenge such measures? This is the first question. And if I may present the second question, it is as follows. In the context of international law, and especially considering the request for an advisory opinion submitted by the Commission of Small Island States on climate change and international law, if a small island state already grappling with the impacts of sea level rise due to climate change has secured UN membership after meeting the criteria for statehood and other UN membership prerequisites, is there a potential risk of it losing its UN membership status? And that's it. Oh, it is not. We just got another question, if I may. I don't know if you rather if I present all the questions together?
Yes.
Okay. So the other question that we have here is, in relation to the litigation in the Court of Justice of European Union, as how effective or successful is the internal review mechanism of the Aarhus regulation considered for litigation in relation to European Union environmental matters? Is it actually an effective way to combat the plowman problem of having to prove individual and direct concern? And that's it for now.
I don't know if Natalia is online. I think she's not. She had to leave. So I'll give the word to Professor Armando.
Yes, so can you? Yes, you can. So thank you very much for the questions. In your case, Francisco, what I would answer is the same, well, not exactly the same, but I can group them in one single answer. So that's what you're actually highlighting is the problem of human rights, not the problem in a negative sense, but that's the point of human rights law. Once you provide international courts with mandatory jurisdiction, and once you provide ecumenical access of individuals to these bodies, the generator center of the international obligations moves from state consent to courts, and more importantly, although indirectly, to non-state actors, individuals or corporations, because once they make a question, the question already has an answer. Look to the requests for advisory opinions. You already have implied what you want courts to say in their answer. So this is a direct implication of moving this generator center to the international obligation from state consent to international courts. Now, the problem of international courts is that they are courts, first, meaning they have to comply with the principle of separation of powers, and second, they are supranational. So if a court under normal circumstances is afraid of stepping in highly divisive, politically divisive topics, if you're a supranational court, you'll be much more reluctant to do that. That's not what the Inter-American or European Court of Human Rights do. They are quite happy to say, if I may say so, under the freedom of speech, they are very keen to say whatever they want. And quite often they say wrong things, if I may now correct myself. And this explains why in the past, and there is a good reason why Turkey is concerned with this, but in the past, European Court of Human Rights has used other treaties according to Article 31st, paragraph 3 of the Vienna Convention, saying this is all part of the same building of international law, so you have to read all of them in light of each other, and then it imposes an interpretation of the treaty which is expressis verbi, which is in another treaty, but Turkey was not part of that treaty. This happened with the abolition of the death penalty. Turkey never ratified that protocol. Actually, that's one of the exceptions on Article 2 of the European Convention. Still, the court said, I don't care if you didn't ratify, now you're bound by it because I decided so. What to do, I'm sure the European Court and the Inter-American Court will not step back. Especially the Inter-American Court has made studies where it actually it says very explicitly, I'm aware of this, I'm aware that states then don't enforce my judgments, but still they are symbolical, so I will do this. I will say this irrespective of state compliance. It's easier for regional courts to do this because you have a greater cultural and political integration. Now, with respect to the causes and membership, I would be surprised if this would appear in the advisory opinion of the submitted to the EAT-laws. Well, first of all, I would be surprised if the EAT-laws actually renders an advisory opinion, since it's obvious that it lacks advisory jurisdiction in that case. But the ICJ may actually refer to this specifically. This was asked, and there is no formal mechanism under the UN Charter to expel a state that has actually already disappeared. But once a state disappears, membership may be lost automatically. This has happened in cases of state succession. The former Democratic Republic of Germany is no longer a member of the United Nations for obvious reasons. Although usually what happens is that you have a new state that assumes the credentials of the former state, and this will not happen in this case. And finally, I'm not sure it was for me, but I took notice of the protests. well, with one note, I noted the use of the adjective harsh measures to repress protests. This is an example where the question already has the answer that you want to see provided and nothing against it. I wouldn't say the measures to repress are harsh, the same way that I wouldn't say that the protests themselves are harsh. So it's normal daily life in democracy. Sometimes we have excesses, but we may have always restrictions to freedom of speech. A good example, we don't have this under, and I will finish in 10 seconds. I have no knowledge of any case regarding climate change, but you have the Arctic Sunrise case regarding demonstrations from the Greenpeace in an oil platform in Russia, where this was actually brought to the European Court of Human Rights. So if you're interested in this topic, that would be the precedent I would look into.
Thank you. Anna?
I'll start with the question by Tessa Trapp. I would say that regarding the effectiveness of the internal review mechanism of the Aarhus regulation, I would say the short answer would be sometimes it will be effective, depending on, again, the case you're making. It's not a specific question about climate litigation, but if you're talking about a non-strategic case or a strategic case, it might be effective in some cases. It's I would do the analogy a little bit with the compliance mechanisms in the Paris Agreement or international treaties. Some defend that these compliance mechanisms are a way that facilitate implementation, compliance, and therefore we don't need to resort to the court. Here, I would say the same with the mechanism of internal review. It may be a solution sometimes, other times it won't be as effective or successful. Yeah.
I think the questions were pretty all answered as much as possible. And I know there are more questions we can. No. Okay, Maria Antonia, please.
Just to add to what Armando said on two of the questions, I think, with respect to the climate protesters cases, there hasn't been anything at the European Court, but there have been several cases at the domestic level across different jurisdictions. So all of these cases are in the Saving Centers database. And we also, in the report that we published with UNEP in July on the status of global climate change litigation, there's a section on climate protesters cases as well. So there's a bit more information there. And then with respect to the case of statehood, I just wanted to add that, this obviously is a very controversial issue and scholars have grappled with this question for many years, but just to note that Tuvalu actually announced, in like a couple of weeks ago at the General Assembly, and also they changed their constitutions to address this issue of statehood in case they are actually underwater in a couple of years, as is predicted will happen. So trying to start addressing some of these issues, obviously not an international law response, but a domestic response that I think is still relevant to note. So that's it.
Thank you, Maria Antonia. Is there any other question? Yes, please.
Trends. Oh, sorry.
Can you present yourself?
Hello. My name is Teresa. Thank you for so much for this entire panel. It's really interesting and I think very topical, as we all know. But since we're discussing trends, one of the trends I think that's very noticeable is also the increase in arguments regarding future generations and their rights. So we've seen this in different cases like Neubauer and especially the Colombian case on future generations. So, of course, there's questions of victim status, which we can discuss later as well. But I just wanted to ask you what you thought in general about the relevance of being able to litigate on behalf of the rights of future generations when it comes to climate change. in light of the fact that they will be the ones who will truly bear the full weight of the consequences of our actions today. Thank you.
So how many time do you have to? I have no idea how to even be topical in this answer. So you're asking for a problem, because this is also the definition of a huge problem to begin with. You don't have, you have some black letter references to future generations. You have a protocol on the rights of future generations under the European European Convention on Human Rights, which has not been adopted yet. So perhaps in the future you may, which means that it's highly difficult to make a very clear direct case based on the rights of future generations. Now, can you be creative? Of course you can. For instance, if you apply children's rights as under the UN Convention on the Rights of the Child, a child is a future generation for some purposes. Even the very notion of what is a future generation is controversial. So you can actually very easily include this dimension in the current case law and before these bodies. Then you can be more creative and you can say that the right to a safe and healthy environment necessarily is about future generations and make it to better substantiate this right. Although you also know that you don't have that many treaties actually referring to the rights, the human right, a standalone right to a healthy environment. So in a nutshell, yes and no, it depends if you want troubles or not, and how many time do you want to spend discussing and writing about this. Not very conclusive, I'm sorry.
It's hard to be. We're out of time. So I'm so sorry. I have to end this panel here. I have to thank all the speakers who were with us, and I hope they will still be with us along the day. I very much appreciate the questions put by the audience here and online. We'll have a small break here, and we will return at 11:30 after the break. Yes. Thank you very much.